Welcome everyone, and welcome to those who are still joining us. We're very excited to be co-hosting this webinar on the implications of the recent Shell judgments with Oxford Business and Human Rights Network and the Utrecht Centre for Accountability and Liability Law. My name is Anıl Yilmaz, and I'm a senior lecturer at Essex Law School, and I'm a co-director of the Essex Business and Human Rights Project alongside Professor Sheldon Leader and Dr. Tara Van Ho. I'll be co-moderating the discussion with my colleague, Dr. Tara Van Ho, who's a lecturer at Essex Law School, co-director of the Essex Business and Human Rights Project, and the co-president of the Global Business and Human Rights Scholars Association. That's a mouthful. And the Business and Human Rights Guru as well. So a few points of housekeeping. This event is being recorded and it will be posted on the Essex School of Law YouTube channel. So if you have to leave at some point, don't worry, there will be a recording. If you wish to remain anonymous when speaking, when asking questions in the Q&A, yeah, I don't think it's permitted to speak in a webinar, although we can allow people to speak probably. You can select to be anonymous in your Zoom settings. I don't know how to do that, but if somebody else here knows, please let everyone else know.
There's a box that you check when you ask your question. So you just check that box that says, I wish to remain anonymous, and then we won't read your, obviously we won't be able to read your name. Otherwise, we will read the names of the people who are asking questions.
Okay, perfect. Thanks, Tara, for that. So we have an impressive lineup of speakers today. We will introduce each panelist when it's their turn to speak. They will each take 10 to 12 or maybe 15 minutes commenting on various key aspects and implications of the cases. We will open the floor up for questions from the audience afterwards. Please use the Q&A function to ask your questions. If you use the chat function, it may be hard to keep track of them. But we welcome your nice, warm messages from the chat. We would like this to be a safe and inclusive space for discussion. So to ensure that we have a zero tolerance policy when it comes to racist, sexist, or ableist comments. Hopefully no one will make such comments, so we don't have to kick out anyone. Today, we will be discussing the implications of two important judgments delivered in early 2021 relating to corporate accountability for human rights and environmental harm. 2021 had a bad start for COVID reasons, but in terms of business and human rights and corporate accountability, it was an impressive start. Both judgments we will discuss rely on, to a lesser or a greater extent, on the 2019 Vedanta and Lungo judgments from the UK Supreme Court on the issues of parent company liability and jurisdiction. So I think, in my view, that makes Vedanta the really monumental judgment in this area, but others may disagree. So the UK Supreme Court judgment in Okpabi and Shell was handed down on the 12th of February 2021, after first being filed in 2015. I'm going to leave Matt and others will talk a lot more about the case, but just a brief introduction. It concerns claims of damage to environment, land, health, and livelihood suffered by two communities in the Niger Delta, which allegedly arises from oil spills from Shell-operated pipelines. The claims were brought against both Royal Dutch Shell plc, the parent company based in the UK, and its Nigerian subsidiary, Shell Petroleum and Development Corporation, which actually operates the joint venture in Nigeria. And the facts and legal issues pertinent to both cases that we will discuss today will be discussed by panelists in more detail. And on the 29th of January, the Dutch Court of Appeals delivered three judgments finding Royal Dutch Shell and SPDC liable in certain aspects of the oil spills affecting three communities in the Niger Delta. As Lucas Roorda put it, this particular case is very significant because it's the first appeals case in Europe that resulted in a victory on the merits for the victims, but also the first case to hold that a parent company actually was under a duty of care with regard to foreign claimants. Both cases have really strong implications in the areas of tort law, company law, human rights law, and access to justice, and we will discuss some of these today. And my final point is, in my view, from a scholarly perspective, I think these cases, these two Shell cases and Vedanta, are really significant because of the very visible dent they made in the legal shields that protect and allow capital to shift risks of their own failure onto communities and the society at large. As important as these judgments are, we do still have a long way to go to see the jurisprudence develop. We are also yet to see the impact of these judgments on corporate practice. Will corporations improve their practices and take human rights more seriously? Or will they take a more hands-off approach to avoid being, the risk of being found to have a duty of care towards communities overseas? So we will discuss these and many other key issues in the next couple of hours. I'm going to pass it over to my colleague Tara Van Ho to kickstart the discussion.
Thank you, Anil. I'm going to actually start a little bit where Anil left off, and that's because we were asked why Vedanta is significant, or sorry, why Accountability is significant. Isn't it just Vedanta 2.0? And for those of you who aren't familiar with Vedanta, it's kind of, if you think of parent company responsibility within the UK, there's kind of a holy trinity of Chandler v. Cape, Vedanta, and now Accountability. And Vedanta set out that when parent companies claim they're going to take a responsibility towards mitigating the impacts of their subsidiaries, that actually does assume a duty of care. And so isn't Accountability just applying that? And to an extent, it is. But I think there's a lot of really interesting developments within Accountability that aren't in Vedanta, that are the extension of that. And for me, one of the biggest, and what I'm looking forward to hearing from the panelists, one of the biggest developments is the difference in the facts and the application. So in Vedanta, you had a parent company that almost unilaterally made the assumptions of responsibility. And the focus within that case was very much around what did the parent company do? And with Accountability, what we get is a little bit more discussion around actually how does the entity as a group, how does a group function as one entity? How does it operate collectively? And that means, what does a subsidiary do? How does a subsidiary delegate responsibility? And that's a question that we haven't had in the earlier cases. And I think it's a really potentially transformative question when we look at applying these cases outside of a parent company subsidiary relationship. The other really practical impact of Accountability is what it should be doing to Shell's operations in Nigeria. Shell has a long history in Nigeria. It is one that is steeped in the colonial legacy in Nigeria. They've been operating there since 1937. And for at least, I've been paying attention to what they've been doing since 1995 with the killing of the Ogoni 9. And I think that's when most Western human rights activists sort of got clued into how deeply problematic Shell's operations in Nigeria were and are. And since then, we keep listening to Shell every single time there's a new oil spill, come back and say, oh, but we reformed, just give us another chance. And that always lasts for about 6 months to a year until the next big oil spill. And then they again blame Nigerians for what's going on. And they just have never actually taken accountability or responsibility for the devastating impact that they have on the environment and on Nigerian human rights. So when we talk about what the impact is of this case, yes, there's a 10,000 mile in the sky understanding of the impact on tort liability, on company law in the UK. There's also that 10 feet off the ground impact. Shell should be finally listening to the courts, right? They've ignored the Nigerian courts for decades, as the Nigerian courts have continually taken this case forward and continually found Shell to be negligent and in breach of statutes. Now, finally, the colonial home state is saying, take responsibility. So maybe, finally, we'll see some change. So with that, I want to turn it to one of the lawyers behind the case and bringing it into the UK courts, and that's Matthew Renshaw. He's been a solicitor at Lead Day's International Department since November 2012, and he specializes in corporate accountability cases. He spent a good deal of that time working on behalf of Nigerian individuals and communities. in claims involving allegations of environmental harm caused by Shell's operations in the Niger Delta. This includes working on a claim brought on behalf of the Bodo community, which was resolved in 2014, and working on the Ogoli and Bili jurisdictional challenges on which the Supreme Court gave its judgment. Matthew has also worked extensively on claims concerning allegations of human rights abuses against artisanal miners at British-owned mines, including in Mozambique and Tanzania. He specializes in seeking to hold British companies to account for serious human rights violations and environmental damage that occurs in other countries. So with that, Matthew, I'm going to turn it over to you.
Thank you very much, Tara and Anil, and some really interesting thoughts there to get us started. Thank you for having me on, and thank you, well done, for organising this event at such astonishing speed. And thankfully for me, and I think probably many of us here, this should be a rather happier presentation than it would have been after the Court of Appeal or High Court judgments in our cases, which went rather less well. I'm going to try and share a PowerPoint just to start, and I'm going to start just by, hopefully that's worked, thumbs up, just by setting out the legal framework and giving you a bit of background to the UK Supreme Court judgment which came out last Friday. I'll try to do this relatively quickly because I know for some of you this will be quite familiar territory, and then I'm going to focus on two overall takeaway points that I have from the judgment. So the UK Supreme Court appeal concerned claims by two different Nigerian communities, the Ogale and Bile communities, and they allege that Shell has conducted its operations negligently in and around their communities, which has resulted in the severe pollution of their communities over many years. And that's just an image of the Bile community and what at one stage were fertile green mangroves, and we now have this as the backdrop to that community. A very quick timeline, the claims were issued on behalf of the two communities in late 2015, so already a considerable while ago now. In 2015 and 2016, Shell made various jurisdictional challenges. In both claims, they challenged the jurisdiction of the court over the claims against both RDS, Royal Dutch Shell, the parent company of the group, and also against SPDC, the Nigerian subsidiary. The High Court at first instance in January 2017 ruled that the English courts did have jurisdiction over RDS, so that issue has fallen away. And the key question remaining was whether the courts had jurisdiction over SPDC, and particularly whether SPDC was a necessary or proper party to the claim. And I've just set out on the slide the test for that. And I've highlighted B, which is the critical question for us here and on appeal, which is whether there's a real issue between the claimants and RDS. And that's the key point on appeal. It's equivalent to the summary judgment test. So the question being asked is the claim against RDS bound to fail? So a pretty low bar, you would hope. Is there even an arguable case that RDS owes a duty of care to these claimants? However, the court at first instance said no, it's not even arguable that RDS owes these claimants a duty of care. The Court of Appeal found various errors of law in the first instance decision, and then conducted its own fresh analysis. And then also, by majority of 2-1, they also found there's not even an arguable case against RDS, although Lord Justice Sales wrote a pretty robust dissenting judgment, which at least gave us some hope that there may be an appeal and that there may be reasonable prospects on that appeal. But this is the main question, the only question of the Supreme Court appeal is whether there's a real issue between the claimants and Royal Dutch Shell. And so moving on, after that brief background to my two main takeaways from the appeal that I'd like to talk about, both of which are positive for corporate accountability, legal cases, and work more generally. The first is that the Supreme Court made it clear that the potential liability of a parent company like RDS for harm caused by operations of an overseas subsidiary like SPDC is broad and can arise in different circumstances in different ways. And I've put up here a slide summarizing paragraph 26 of the Okapabi Supreme Court judgment. We had identified these 4 routes from the Vedanta judgment as situations in which parent company liability might arise. And the Supreme Court approved that formulation, although they added absolutely correctly that these are not exclusive ways by which a parent company might owe a duty of care. And just quickly looking at those routes, one is uncontroversial, but in relation to group-wide policies, the Court of Appeal in the Shell cases had held that group-wide policies alone could never be enough for a duty of care. The Supreme Court made it clear that this is wrong. Group-wide policies dealing with a relevant area of the operation of a subsidiary could lead to liability of the parent company. And given, as you will know, that many parent companies of multinationals have policies covering environmental and human rights issues, this clearly has potential relevance to future legal claims and the potential liability of parent companies. And in relation to Route 4, the Supreme Court reiterated that this is a possible route to liability, where a parent company has publicly undertaken a responsibility. So where a parent company makes public statements about its commitment to or responsibility for an issue, it can then potentially be held liable if it fails to act on those commitments. And Shell, in this case, in their submissions to the Supreme Court, essentially invited the court to restrict or somehow limit this provision, describing it as controversial and exceptional and things like that. But the Supreme Court very starkly rejects this and reiterates that this is a potential route to liability. And this is a really important principle, I think. It makes it clear that if a company talks the talk, it has to follow through, or it faces possible legal consequences. I'm just going to hop out of the very short PowerPoint now. And similarly, the Supreme Court expressly rejected the Court of Appeal's narrow focus on the operational control of the parent company over its subsidiary as the test for parent company liability. They make it clear that that is not the test. It may be a useful starting point, but the analysis should be much broader than that. So the message from the Supreme Court seems to me to be about the broad nature of potential parent company liability and the multiplicity of ways in which that can arise. And whilst the court is not making any new law here, it is giving important guidance on how the law should be applied in the context of parent company liability, and making it clear that a narrow or restrictive approach to parent company liability is not appropriate. And just to add on this as well, that these sections of the judgment are relevant not just to the arguability of a duty of care, so at the jurisdictional stage, but they are equally relevant to establishing a substantive duty of care against the parent company at a trial. So that was the first thing to flag. My second sort of takeaway or theme I'd like to discuss, and in some ways it's related, is how the Supreme Court sent a very clear message to lower courts about not setting the bar unreasonably high for claimants in these sorts of cases at the jurisdictional stage, and not conducting a mini trial on the evidence available at that stage. And in a sense, it was actually quite helpful here that the claimants had lost at the first 2 stages in the High Court and the Court of Appeal. In Vedanta, the situation was again, as many of you will know, the claimants were successful at first instance and the Court of Appeal and the Supreme Court. And the appellate courts were or to some extent limited to saying nothing really has gone wrong here, no need for us to interfere, nothing to see here, let's move on. Whereas in the Shell case, the Supreme Court pulls up the Court of Appeal and sets out pretty starkly where they went wrong and how they went wrong. And again, whilst in some ways this is just emphasizing or clarifying the correct application of the summary judgment test, it makes it clear how that law should be applied in cases of this nature in the future. The main finding of the Supreme Court, which led them to overturn the Court of Appeal's judgment, was the finding that the Court of Appeal had made an error in inappropriately conducting a mini trial and seeking to evaluate the evidence at the jurisdictional stage. The Supreme Court was particularly critical of the Court of Appeal's approach to disclosure and emphasized the particular importance of disclosure in these sorts of cases. Lord Briggs in Vedanta had said it was blindingly obvious that disclosure would be important. Lord Hamlin said in the Shell Supreme Court judgment that proper disclosure is of obvious importance, and Lord Bingham had made a similar point a while ago in one of the Cape cases. But the Supreme Court really emphasized this point that disclosure of internal company documents and materials, and not just those that have been handpicked by the defendants, is likely to be critical in determining a parent company's liability. So the clear implication in my view, that can be drawn from the judgment is that very rarely will it be appropriate in parent company claims in the future to find prior to a trial, prior to disclosure, that a case against the parent company is bound to fail. And this has two consequences. It means, firstly, that cases against parent companies are not likely to be suitable for summary determination, for summary dismissal. So they should proceed to trial now and full disclosure. And as has been noted, there have been very few trials of cases like this previously. And also that if claimants are seeking to join a subsidiary company as a necessary or proper party to a claim, the expectation will be that the real issue limb of that test is likely to be satisfied. So just to wrap up, I tried to focus on some of the positive aspects and implications of the judgment, but equally we should be clear that it doesn't in any way represent a silver bullet or anything close to it to corporate accountability claims of this nature. Those cases remain very challenging, very complicated. There are often many different sorts of hurdles. And even in this case, there is still a long way to go before there's any prospect of a successful resolution for the claimants. So it is certainly encouraging, this judgment, and I think people in the corporate accountability world, rightly from this and from the Dutch judgment and other positive developments recently as well, can take a lot of encouragement and heart. But equally, there's still a long way to go before we see proper accountability for companies.
Thank you, Matthew. That was a really nice overview of the case and its implications. And I'm really hoping that we can come back to some of that language about discovery in the question and answers, and also in some of the subsequent presentations. Because while I focus on the corporate law side implications of the judgment, I thought that was a really nice striking down of what we've seen, which is multinational corporations constantly drawing these cases out, making them as expensive and as difficult as they can at the jurisdictional phase, and never getting us past that first hurdle. So I thought the Supreme Court's judgment there, and I thought you explained it really nicely. Now the Supreme Court's judgment there opens up some possibilities.
Tara, can I just say something? We're getting questions in the Q&A, and I just wanted to say we're going to leave all the questions to the end. We're just collecting them. Keep them coming, but we're not going to answer them just yet. Thank you.
And before I move on to Lucas, I do want to say something that Anil said in the chat, and I meant to mention in our introductions, which is congratulations to Lide for another successful judgment at the Supreme Court this morning against Uber, finding out that a determination that drivers are employees, which should not have been a particularly shocking decision, and yet we had to go to the Supreme Court of the United Kingdom to get it. So
fantastic news. I didn't realize you're following the news more closely than me, Tara. That's great news.
Oh, we get the WhatsApp group messages on these things. Fantastic. So we're gonna move on to Lucas. Dr. Lucas Roda is an assistant professor at Utrecht University School of Law and a postdoctoral researcher at the Utrecht Centre for Accountability and Liability Law, where he mostly conducts research on foreign direct liability litigation in Europe. His PhD thesis concerned jurisdictional aspects of these cases as a potential barrier to remedy for victims. So Lucas.
Thank you, Tara. Yeah, and also thank you for Matthew for the first very insightful presentation, and also for the now 185 participants to the session. And back when I started my PhD on foreign direct liability, I was not aware there were so many people actually interested in cases of this type, and also prepared to come and watch this session. What is early in the morning for me, but I know much more early in the morning for a lot of other participants today. So thank you very much for joining in. What I will try to do is give a couple of insights into the Dutch case specifically. So because the audience is mostly international, with the exception of my UCall colleagues, thank you for participating as well. I'll go in a bit more detail into the facts and the background of that case, although it overlaps to a certain extent with the Okpabi case, and some parts we can sort of skip over. It's also a very long judgment, so I'm skipping a lot of the details, a lot of the preliminary issues, also in the interest of time. But let me grab my PowerPoint for that then. Yeah, here we are. So it's the case of 4 Nigerian farmers and Stichting Milieudefensie, which I think in English is Friends of the Earth Netherlands versus Shell. And yeah, I mean, I could fill this entire presentation with more images of what oil spills and oil pollution is actually doing to that region. I think for a large extent this overlaps with what Matthew just said. So I won't go into much more detail about that, but I do want to emphasize that if we look at judgments like these, as especially as Western academics, we tend to think in abstract terms, while this sort of pollution really destroys for generations the livelihoods of people in a region that is as far as I know, I think 2 or 3 times at least of the Netherlands in terms of size, and that the impact is much larger than we sometimes realize. And that is especially important to say because we're talking about, because this is a Dutch case, which and filed by 4 specific claimants. It's not a big group claim as the Okpabi case is. All this damage is really sort of put into the sort of individualized mold, while the real implications are much broader, and that's something I think we should all sort of keep in the back of our minds. But that is a preliminary issue. So we're talking about 3 different incidents: a spill near the Aruma village, a spill near the Goy village, and near the Ikot Ara Udo village. I really hope I'm pronouncing this correctly. I try to practice this because, again, this is really important for people on the ground. But these are spills caused by leaks to pipelines, and in the third case, by an opened wellhead, which I thought I put on the bottom right corner of the screen. This is basically what it looks like on the ground. I think they call it a Christmas tree, even, which caused leaks of respectively 400 barrels of oil, 150 barrels of oil, and 629 barrels of oil. And I've put the exact amounts here because 629 barrels might not sound as much, but it's 100,000 liters of oil spilling over farmlands and fishing grounds. Summons was filed in 2008 against both the Nigerian subsidiary SPDC and against the parent company Royal Dutch Shell, which is of course registered in the UK but has its headquarters in the Netherlands. Shell's main line of defense was basically that these spills were not caused by negligent maintenance, but by sabotage. And of course, sabotage of oil infrastructure is quite common in the Niger Delta, and there's a long history of why that is the case. But that in of itself is not very exceptional. And indeed, the district court in 2013 said, well, for most of the spills, we do consider sabotage the most likely cause, and therefore Shell is not liable for the causation of the spills per se. But in the last case, the Ikot spill, so the opening of the wellhead, Shell should have taken more countermeasures to prevent sabotage. In this case, I think they even said they removed the little tap or little wheel which you can use to open the wellhead, but you could basically open it with a simple with simple tools, and they should have done much more to block that wellhead. But the other claims were dismissed. But now the Court of Appeal said, well, no, we're gonna, it's completely reversed the decision of the district court, and held SPDC liable for the first two spills. So the leaks near the Guruma and Goy villages. They've only produced an interlocutory decision in the Ikot Udo case, because they still want to see more evidence on the extent of the damage as well as on the potential countermeasures, because they also consider sabotage to be the most likely cause. And I will, for the rest of my presentation, focus on the first two cases and not on this interlocutory decision. Now, just as in the Okpabi case, jurisdiction is based on the domicile of the parent company in the Netherlands, and then SPDC was named as a co-defendant, which is also possible on the Dutch procedural law, specifically on Article 7.1 of the Dutch Civil Code. It looks similar to the necessary and proper party gateway that Matthew just explained, but it functions slightly differently. And I will, at the end, come back to the differences and why that matters quite a bit for cases like this. The court held SPDC liable both for causing the spill, or at least for the causation aspect of the spill and its initial response. It hasn't held it's the parent company liable for the causation, but it did recognize that RDS has a duty of care. Oh, sorry, it says to install an RDS, but it should be a leak detection system, so an LDS. So it has a very specific and narrow duty of care, which it has to discharge within a year. Otherwise, it can also be held liable for certain damages. Now, that I think is the most interesting aspect of the case. The first finding, and I think both Anil and Tara already mentioned it, the first finding of a duty of care on a parent company on the merits on appeal. And that's also what I'm going to be focusing most of the presentation on. But first, I want to talk a bit about the liability of the subsidiary, because most of the, all of the damages will basically be coming from this finding. And this is quite interesting because the court applies Nigerian statutory law, specifically the Oil Pipelines Act 1956, and that act contains a strict liability provision for operators of oil pipelines. So basically, operators like Shell, if there's any damage as a result of spills, you're liable for the damage caused by those spills, unless you can prove that those spills were caused by malicious acts of third parties, basically crimes, so sabotage. And of course, that was the main line of defense by Shell. Like, okay, there's sabotage going on, and that was the main reason why these spills occurred. And the main question that the court had to answer is, what is the standard of proof for showing that sabotage was the actual cause of the spill? And the court ruled that in this case, it is the standard is beyond reasonable doubt. So basically the same burden you would have to meet if you were charged, if this would be a charge in a criminal trial. And Shell could not prove to that level that sabotage was actually the cause of the spills. The court did say it's still considered sabotage the most likely cause, but that in itself was not sufficient to meet the beyond reasonable doubt standard. So there was still strict liability for SPDC for the cause of the spills. Now, it also considered the question of, is SPDC liable for its response to spills, which it decided on under common law tort of negligence? Well, it was foreseeable that leaks could occur, especially also given the risk of sabotage, that access to sites of the leaks where the pipelines is would be or could be difficult. And this is interesting because Shell had said, well, or the response was made much more difficult because local communities wouldn't give us access to that site. And the court said, well, that may be the case, but you knew that in advance. You knew it's going to be tricky for investigation teams to go on the ground, either for security reasons or because local communities might not appreciate you being there. And you have to look at other ways in which you can detect whether actual spills have gone on. And that, for instance, could be done by installing such a leak detection system, which is part of a piece of technology which detects sort of pressure drops in the pipeline. And also in the Goy case, Shell actually did like a survey with a helicopter, but it did it 1 or maybe 2 days later than it could reasonably have done. So the court said, well, SPDC is also liable under the tort of negligence for failing to adequately respond to the leaks when they first occurred. And then thirdly, the question of whether they adequately cleaned up the site. And there the court, and I'll do this very shortly, said, well, in this case, the standard to which Shell should actually clean up the oil, even though there's some there's some residual pollution being detected, but they met that standard, and there's no further duty for SPDC to clean up what is left. And this it hasn't gotten a lot of attention yet, but I think in terms of damages, this may be a bit of a setback for the claimants as well, because they didn't just argue the immediate damage after the spills occurred, but also all the residual damage that has since then occurred because of those leaks and because of the residual pollution. I think some of the images Matthew just showed are also related to this sort of ongoing pollution. But this is sort of, you can say, the bulk of the judgment. But legally speaking, what of course just as interesting is the liability of the parent company. And I will not repeat everything Matthew just said, because basically the court goes to the same precedent under the assumption that English common law cases have persuasive authority in Nigerian law and Nigerian common law. And this is where the decision gets a bit strange. And if you're familiar with English law, you might already see that in my summary of the judgment, there's a couple of strange, well, there's a bit of a conflation of different tests, because the court says, well, we're going to take Vedanta as leading case, but then they apply within that context the threefold test of Caparo v. Dickman, which for establishment of a new duty of care. But in Vedanta, and as later confirmed in Okpabi, the court had the UK Supreme Court specifically said, no, Caparo is the wrong test to use. It's too stringent because there's no new sort of liability being created, and you don't have to go into the whole fair, just, and reasonable test to assert whether or not a parent company is under duty of care. And here the Dutch court actually does exactly that. So what they do, they also focus very much on what you could call Vedanta Route 1. So whether or not RDS interfered with its local subsidiary, actively took actions to take over part of the management of SPDC. And they do rule that in, sorry, let me just roll back a bit. The first question is, did they have duty of care with regard to the cause of the spill? And there the court also adds this very strange condition. It says, well, you can only have a duty of care on a parent company if the subsidiary itself acted wrongfully. Now, as I explained in the previous slide, the liability of SPDC for the causation was based on strict liability, not on wrongfulness. And then the court says, well, because there is no determination of wrongfulness, you cannot also have a duty of care on a parent company, which, as far as I can recall, and again, I'm really looking forward to the experts in English law in this session, is nowhere in the relevant precedent. And then they also look at the involvement of RDS in the response to the spills and say, well, RDS was not involved with SPDC's operations at the time of the spills, but after 2010, they became much more involved with preventing oil spills, especially in its Nigerian subsidiary. So it assumed a duty of care, at least after 2010, but then very specifically on preventing oil spills through the installment of a leak detection system. This is also why I've been sort of mentioning this LDS quite a couple of times. And this is where the court actually finds a duty of care on RDS. And also and orders it to ensure that SPDC installs such an LDS within a year. And again, with regard to the cleanup, the court considers that there was no wrongfulness on the part of subsidiary, so there can be no wrongfulness on the part of the parent. So these are basically the findings, and I've summarized and simplified to a large extent. Let me just close off by giving a couple of impressions, at least as I see it. And of course, the first is that this is an important victory for the claimants, first of all, but also I think to victims and potential victims of wrongdoing like this worldwide, and then like by extension also anybody interested in corporate accountability. I mean, it's the first findings on appeal on the merits in favor of claimants. We have the first finding of duty of care incurred by a parent company, which and of course the UK Supreme Court had already been moving towards making this a much more tangible option, but we now know for absolute certain that it's no more, not anymore a hypothetical. If only because even though Shell can still appeal this case to the Supreme Court, the application of English law cannot be part of that to that appeal. Jurisdiction was, of course, already asserted in the interlocutory decision, but that part could still be contested before the Supreme Court, because the defendants could only appeal that decision together with or once the actual decision on the merits had been issued. So it could be that they're still going to contest that joint claims construction before the Supreme Court. But if you then sort of go a bit beyond the actual case, you can see that the findings that the court makes with regard to SPDC's liability, while of course very important for the victims, are very much connected to the particular facts of this case and also the particular applicable law, so the Nigerian Oil Pipelines Act, that may be very relevant for future cases involving Shell in this region, and perhaps comparable facts. And we know Shell is still very active there, so in that respect, it could be relevant for other cases, but any other case from any other jurisdiction involving any other defendants will be a completely different new factual assessment. So in that sense, the decision doesn't sort of have many broader implications, at least as I see it. The application of the Vedanta precedent is, well, as I mentioned, it's quite questionable. There's no mention of the 4 routes in Vedanta. There's only mention of the Caparo test, which, as confirmed by the Supreme Court now, is the incorrect test to apply here. There's a very narrow view of potential interference by the parent company. So I think what Matthew just outlined on how a parent company can have a duty of care by virtue of its group-wide policies or by virtue of its holding itself out to be supervising its subsidiaries, it's not really in this judgment. And you have this strange extra criterion of the wrongfulness of the subsidiary, which again, I think misstates the relevant English cases. And what you also have is, because you have this very narrow view of what can constitute a duty of care, namely specifically parent company interference, this might discourage companies from actually doing that interference to their subsidiaries and just rely on those broader group-wide policies, which again should potentially lead to duty of care, but not as the court sees in this case. And I think one very practical thing to mention is that even without very lengthy procedural litigation, because the Dutch criterion for joining cases is much more easily met than the necessary and proper party criterion, it's still 16 years after the first spill, because before we had this judgment. It's been, I say 11 years, but it's actually 12 years since the summons. 2 claimants actually died during the proceedings, and they were continued by their descendants. So you could really question, like, what is actually won by a decision like this. I mean, symbolically, of course, it's a very important victory. We'll still have to see, by the way, how the extent to which it actually leads to compensation. but 16 years is quite a long time to get actual satisfaction. And I think in future cases that has to be much more quickly to have any sort of real, tangible, usable remedy. Now, I had a lot of ideas on future prognosis, but I know I've run out of time, so I will stop here and maybe reserve that for questions. Thank you.
Thanks so much, Lucas. That was a really fascinating overview of the Dutch case. Before I move on to our next speaker, I do want to note that please make sure if you're a participant and you have a question for us, do check that, do use the Q&A tab, not the chat tab, so we can keep all of the questions in one place. And then for the speakers and panelists, if you could check out that Q&A tab, particularly after you've talked, to make sure that you can answer any quick questions on there. We're getting a lot. We have 16, if my math is at all good, which is not a guarantee. We have 16 questions already, and we still have 3 more speakers. So we're gonna have to consolidate those in the end. Do check out both the open and the answered questions, because some of the questions and the answered questions are actually quite interesting and good and things we want to come back to. So I returned from the US yesterday and I'm still jet lagged. And I thought that I was like, you know, a warrior for business and human rights by waking up at 11 o'clock my time or 9 o'clock my time. And then our next speaker agreed to speak at 4 o'clock in the morning her time. And so Rangi, we are deeply indebted to you for doing this. You are the true warrior for business and human rights and a true inspiration. All right, so Dr. Ibironki Odumosu Ayanu is an associate professor at the College of Law at the University of Saskatchewan. I'm so sorry. Prior to joining the University of Saskatchewan, she was a sessional lecturer at the Faculty of Law, University of British Columbia. She earned a PhD in law from the University of British Columbia. She's a barrister and solicitor of the Supreme Court of Nigeria. Dr. Odumosu Ayanu is one of the editors of the African Yearbook of International Law. She's a member of the editorial boards of the Business and Human Rights Journal, the Journal of African Law, Transnational Human Rights Review, and the African Journal of International Economic Law. She's a member of the editorial board of the Law and Society Review and has served as vice president for conferences of the Canadian Law and Society Association. She teaches or has taught contracts, business organizations, and international law, and has received the University of Saskatchewan's Provost College Award for Outstanding Teaching in Law. Dr. Odumosu Ayanu is a recipient of numerous academic awards, fellowships, and research grants. Her research focuses on international investment law and natural resource development. She also has interests in socioeconomic development, human rights law, and African international law. Her research has been published in several leading international journals and books, and she is co-editor of Indigenous Industry Agreements, Natural Resources, and the Law, published in Routledge in 2020. So Rangi, I turn it over to you.
Thank you very much for that kind introduction, Tara. And just as Tara said, we were having this conversation, this chat earlier amongst the panelists before we started. And people wondered why I agreed to speak at 4 a.m. my time. And I'll tell you why. The subject of our conversation today, of our discussion today, is something that is I'm particularly interested in for 2 reasons. One is personal, and the second is professional. As you may have guessed, I am Nigerian, and I am keenly aware of the multiple interests that are implicated in Niger Delta relations. All of the cases that we're looking at today, well, not all of them, Lugowe, for example, is not Nigerian, but the Shell cases that we're talking about today are Nigerian cases, and that awareness of what has been happening with Shell and oil and gas development in Nigeria is something that has driven much of my research on the impacts of the law on local communities for much of my career. And I first started studying Nigerian oil and gas law as a law student, and then later moved on to become a student of international investment law. I apologize if my voice sounds the way it sounds. I think I woke up too early this morning. So my brief remarks today will incorporate thoughts from these two areas. And by these two areas, I mean oil and gas and international investment law. And my assignment from the organizers is in line with my work to focus on the local community dimensions of our discussion, and also to bring in some perspectives from governance with regard to the African Union and African countries. So that's what I'll do. And I would like to say a big thank you to the organizers, especially to Anil and to Tara, for the invitation to this amazing gathering today, and to all who have taken time out of their day to join us, and to all the panelists, and really to Matthew and Lucas for leading off that way. I don't need to talk about all of those things. I can just go ahead and make the more general points that I like to make. Today we'll focus on the jurisprudence of European courts, but I'd like to start by noting that it appears that there is a willingness by some courts, not only in Europe, but elsewhere, to find jurisdiction where there is alleged human rights violations by businesses operating in host states. And I'd like to start with a recent decision of Canada's Supreme Court. I have to talk about Canada in this. In Nefson and Araya of February 2020 decision of the Supreme Court of Canada, a split Supreme Court found that Canadian courts have jurisdiction to hear a claim against Nefson, a Canadian company by Eritreans who worked at a mine that was run by its subsidiary. They were claiming that what had occurred violated customary international law. And the majority of the court noted, as I put on the slide, that it is not plain and obvious that corporations today enjoy a blanket exclusion under customary international law from direct liability for violations of obligatory, definable, and universal norms of international law, or indirect liability for their involvement in complicity offenses. Ultimately, for the purposes of this appeal, it is enough to conclude that breaches of customary international law or use cogents relied on by the Eritrean workers may well apply to Nefson. So in the Nefson example, we have a case that is based on customary international law. In the cases that we're looking at today, the focus is on torts, already demonstrating that there is a variety of approaches to grounding these claims. I like to identify two general challenges as we go on. And I frame it this way because I want to start by noting that in spite of the somewhat favorable lens by which some courts have started to view jurisdictional and even liability issues, for example, with the Okabi case, the Lungongwe cases, leading to relatively favorable results on jurisdiction for claimants before the UK Supreme Court. And as we've heard from Lucas, the Dutch Shell cases as well. Many hurdles remain for claimants seeking remedies before foreign courts for harm that they suffered in host states. And the first general challenge that I identify is ironically identified as part of commentary to the UNGPs. The second foundational principle of the state duty to protect human rights in the UNGPs is what I put there in the first sentence on this slide. But then in the commentary, the UNGPs go ahead to note that at present, states are not generally required under international human rights law to regulate the extraterritorial activities of businesses domiciled in their territory and or jurisdiction. So there's that point that there isn't really an obligation on states, and then the UNGPs go ahead to note that, but there's no prohibition on them doing so. So while these decisions that we're talking about this morning are not strictly regulations, they do provide some direction regarding when courts will assume jurisdiction to determine the liability of companies for the extraterritorial activities of their subsidiary. So, so that's the first point that I want to note in terms of challenges. The second challenge that I want to note is one that I hear of quite often. And this time the Supreme Court noted this in Vedanta and Lungowe when it referred to looking at cases like this with anxious scrutiny. It was talking about the challenges that sometimes arise. In this quote that I picked up from the decision, the court said, picking up from the middle of the quote there, that the exception, an issue whether substantial justice is obtainable in one of the competing jurisdictions may require a deeper level of scrutiny, not least because a conclusion that a foreign jurisdiction would not provide substantial justice risks offending international committee. And that's an issue that one hears over and over and over again. And regardless of the merits of that argument or the side on which one lands on that argument, it is one argument that is often referenced and adopted as justification for inaction. So I do note these two general challenges, knowing that my co-panelists would identify some more specific challenges. And I note them because in the final slides in this brief remarks today, I do find some ways to respond to these challenges. So when lawyers and scholars begin to analyze questions of jurisdiction and liability, I think that there is often a risk that we do not pause to ask who the affected parties are. And given my focus, but that hasn't happened today, I think that Matthew and Lucas have done a fabulous job of giving us the background to these cases, telling us who these people are, telling us who the challenges are. But I do identify them because of where I'm going in my conclusion. So both the UK Court of Appeal and Supreme Court decisions are quite instructive in identifying the parties to this case. So as Matthew noted earlier, we do have Royal Dutch Shell being the parent corporation, being a party to this claim. And then we also have SPDC, the Nigerian subsidiary. And SPDC operates a joint venture agreement between the Nigerian National Petroleum Corporation, which is a commercialized entity that operates on behalf of the Nigerian government, being a part of this JV agreement. We have Shell itself being a part of it, Total and Ajib. So they're all parts of SPDC, the joint venture agreement that SPDC operates. And the claimants, as Lucas was noting earlier, the claimants on the Dutch side were more individual claimants, but for the Shell decision that we're looking at as part of this conversation this morning, we have a larger number of claimants. On the Ogale claim, 40,000 community members. On the Bile claim, over 2,000 individuals are involved. So it starts to tell us the extent of what we're talking about and the implications of these conversations that we're having today. So these are not claims that are brought by just one person and how it affects them. These are community-wide challenges that people face with regard to these types of claims. And in a world of states and investors, such as those that I've identified in the previous slides, you can start to ask the question, where does one locate these claimants? How do they proceed? And the cases that we're looking at today are not alone in dealing with these types of questions. In spite of these cases, though, and the earlier panelists have started to allude to this, there's so many questions that remain on a general scale. When will a court of the home state assume jurisdiction? When will other foreign courts assume jurisdiction? On what basis will courts assume jurisdiction? I'll give you an example from Canada that talks about customary international law. We're looking at some tort cases today. So there's so many ways or so many bases for grounding these types of claims. When will parent companies be liable for the acts or omissions of their subsidiaries? These are so many questions that still remain on a global scale when we deal with these types of issues. And here I bring it to what I really want to talk about in the last few minutes of these remarks as to how we can start to respond to these issues. So in these three final slides, I lean on investment treaties to show what is possible. I do not lean on these treaties as an uncritical subscription to investment treaties generally or to international investment law. I just use them to show what is possible. So African countries, of which Nigeria, of course, is a part, adopting a direct approach to some of these questions that have been raised today, although the circumstances remain limited. So I put a list of 4 instruments on this slide. The first two, the Nigeria-UK Bilateral Investment Treaty and the Netherlands-Nigeria Bilateral Investment Treaties, are part of what is known as first generation bilateral investment treaties. And these instruments are mostly investment protection and promotion instruments. They don't deal with many of the types of issues that we're interested in today. The latter 2 instruments are instruments that are beginning to turn attention to business and human rights questions, as I would look at in the last 2 final slides. I put a list of 2 cases beneath the Netherlands-Nigeria bit. These are cases that Shell has initiated through ICSID against Nigeria. One of them is very recent as less than 10 days ago. So we're still looking ahead to see how that will go. The 2007 claim was one that was discontinued for reasons between the parties. So there's this generational shift in these types of investment treaties, at least within the African context. And I want to show what the ECOWAS Supplementary Act on Investments and the Morocco-Nigeria bit are doing as a response to some of these questions that we raised today. So the first one, the ECOWAS Supplementary Act on Investments. It may not answer all the questions, but it responds to the 2 general challenges that I outlined earlier. And this instrument, actually both instruments, I need to mention this, they're limited instruments for several reasons, but they're also limited for one very clearly observable reason, and that's the fact that these are instruments that apply between or among African countries. The reason that I added the Nigeria-UK bit and the Netherlands-Nigeria bit is that those are the bilateral investment treaties that relate to the cases that we're talking about today, right? So we're talking about UK cases, we're talking about Dutch cases. The first generation bits are the bits that deal with the types of cases that we're talking about today. But the bits that start to answer some of those questions, the treaties that start to answer some of those questions, are treaties among African countries. And often these types of cases are in the types of cases that are dealt with amongst African countries. So I go back to the ECOWAS Supplementary Act. This is an instrument that includes specific human rights obligations for investors. And for our purposes today, Article 29 of this Supplementary Act is what is relevant. In Article 29, the Act says that home states shall ensure that their legal systems and rules allow for or do not prevent or unduly restrict the bringing of court actions on the merits before domestic courts relating to the civil liability of investors for damages resulting from alleged acts or decisions made by investors in relation to their investments in the territory of other member states. the host state law on liability shall apply to such proceedings. So this is an instrument that directly deals with what we're talking about today, saying that, look, you can bring these types of actions before host states, and it responds directly to those two challenges that I identified earlier. The Morocco-Nigeria bit is one that is widely talked about. It also includes investor obligations. And in Article 20, it includes a provision that says that investors shall be subject to civil actions for liability in the judicial process of their home state for the acts or decisions made in relation to the investment, where such acts or decisions lead to significant damage, personal injuries, or loss of life in the host state. So these are instruments that are beginning to respond to some of the issues that we're talking about today, bringing these types of claims that we're talking about today before the home states of investors. So my brief remarks today really highlight the need to reinvent the law to fully incorporate affected communities as a core group of stakeholders. I often think about these things within the lens of, or from the lens of international investment law. And it's an area that has significantly focused just on states and foreign investors. And as these provisions that I highlight demonstrate, such reinvention is not outside the scope of reason. For many years, international law only recognized state-to-state dispute settlement in investment matters. It required home states to espouse the interests of investors domiciled in those host home states. But that changed to permit foreign investors to initiate claims on their own. And a shift to fully incorporate these affected communities that we're talking about today, I think, is also something that is necessary. And international investment law, to a limited extent, I have to admit, is beginning to deal with some of these, beginning to respond to some of these. And the extent to which it would do so or be successful is something that we're yet to see. I'll stop there and may add a few thoughts when we deal with the questions. Thank you very much.
Thank you so much, Ronke. I'm going to take over the moderation from Tara for a little bit. It was really fascinating to hear the investment law dimension of this, all of this. As an investment law geek myself, I was very excited to hear your presentation. And it actually links really well with some of the discussions on questions of access to justice and where this case will be going, the English case, when we refer to this case. I kind of neglect a bit the Dutch case, but where the Okpabi case will be going to next, the exit claim that was brought by Shell recently can be important because on one hand, Shell might be arguing before English courts that the case should be heard in Nigeria, and Nigeria has a robust legal system. And on the other hand, bringing possibly this exit claim, arguing that Shell doesn't have a robust legal system. But this is all speculation because we don't know what the exit case is actually about. We might never find out. And that all is an illustration of the kind of the catalog of legal protections that I meant to mention at the start of the event that are available to investors, to corporations, to business. The Code of Capital, as Katharina Pister has put it in her book, where you have these big catalog of protections that are available to businesses. And we have to really work hard to carve out a little bit of space through these accountability measures, litigation, maybe human rights due diligence in the future if you know that becomes more widespread. I'm going to now move on to our next speaker, and I'll quickly introduce her. So now we are going to have Katya Aristova, Ekaterina Aristova, speaking to our audience. She's a postdoctoral fellow at the Monteverdi Institute of Human Rights in Oxford, where she coordinates a project on civil liability for human rights violations. She is also a co-convener of Oxford Business and Human Rights Network, who are co-sponsoring this event. Katya's PhD explored private international law aspects of tort litigation against transnational corporations. I'm looking forward to seeing that in print as a book. The floor is yours, Katya.
Thank you very much. And thank you very much, Anil and Tara, for organizing this event in such a short period of time and for inviting me to be part of such a knowledgeable panel of friends and colleagues. So I'm just going to share my screen. All right, I hope you can see it. Please tell me if you don't. Okay. So I'm going to focus a bit more on the Accountability versus Shell case and its implications. And there are so many things that I want to share with you. So some of the statements I will make only briefly, but happy to elaborate them further during the Q&A session. So as Matthew has already nicely explained, the Accountability versus Shell has reinforced its own jurisprudence in Vedanta decision, which set out at least four routes under which a parent company's duty of care may arise. And Accountability further established that a real issue to be tried arose under Vedanta routes mainly 1 and 3, which is taking over the management or joint management of the relevant activity of the subsidiary and promulgating group-wide policies and their implementation by the subsidiary. And in doing so, the Supreme Court made few very significant findings which have already been pointed out by previous speakers, that it's inappropriate to conduct a mini trial at the jurisdictional stage, and that the internal corporate documents are of crucial importance for the parent company liability cases, and then the key is future disclosure, which may materially add to or alter the existing evidence. Now I'm joining Tara in saying that Accountability is a significant decision in its own, even though it has only clarified Vedanta. But I think its significance is important for two reasons. Well, first of all, only a small number of tort cases against multinationals has so far advanced to the merit stage in the English courts, and which means that the parent company liability rules are still evolving. And having a judgment now which further explains and clarifies how management control can lead to liability is certainly advancing our knowledge and the business and human rights field itself. And then the second point is that it's clear that the bar for claimants commencing proceedings in the English courts is lower than it was previously thought, which hopefully will enable quicker process to the merit stage from the jurisdictional stage, and in this sense the Accountability decision certainly facilitates access to justice. While I was preparing, I was anticipating a question about hands-off approach, and it was indeed already asked by the audience. And the thing is whether development of parent company jurisprudence can incentivize parent companies to distance themselves from the overseas operations. Well, it's of course an open question, and indeed some companies may choose to do so, but I don't personally feel that, at least in Europe, this is going to be a wide trend, because businesses are increasingly pressured by stakeholders, by consumers, by the investors to maintain good reputation and a positive brand image in relation to human rights and environmental policies. And the requirements to disclose human rights and environmental policies already form part of the law, and I refer particularly to the UK Companies Act, to Modern Slavery Act, listing regulations, and ESG legislation. And many multinationals have publicly committed to supporting UN guiding principles. Therefore, I think that it's particularly important that Supreme Court in Accountability did not focus on the restrictive approach of actual control, but it stressed the importance of public statements in developing parent company liability rules. Now, I was asked to talk a little bit beyond the Accountability Shell, its implications, and particularly talk about the cases which do not focus exclusively on parent-subsidiary relationship, but where the wrongful acts have been committed not within the corporate group itself, but by the third parties such as police or armed criminals or paramilitary forces. And I have distinguished two types of cases in this context. This first one, when violation took place on the site run by the overseas subsidiary, but the corporate group is not itself immediately associated or involved in these crimes. And then the second type of cases is a lot more complex, where parent company is alleged to be complicit in the wrongful behavior of the third parties by providing them with money or other forms of assistance. And I will talk a little bit about each of these different types of factual circumstances. So many of you might have already heard about AAA versus Unilever case, which is another high-profile parent company liability case that unfortunately did not go ahead in the English courts. So the claimants were employees at the Kenyan tea plantation, which is operated by the Kenyan subsidiary of Unilever Group, and there was a nationwide breakdown in law in order following elections, presidential elections, and as a result, there were riots on the tea plantation, and armed rioters committed violent acts. And the claimants have received severe injuries. The parent company or subsidiary have not been involved themselves in the crime, but the claimants still argued that both companies owed them a duty of care and had failed to fulfill the duty by failing to put in place adequate crisis management policies. But the High Court and Court of Appeal ruled that the case will not proceed before the English courts. So now actions in this case were largely attributable to the third-party criminals, and the case was decided before Vedanta, but if you look through the judgment, you can see that the Court of Appeal only considered 2 examples of parent companies' interventions that could give rise to duty of care, which eventually became routes 1 and 2 in Vedanta. So the Court of Appeal in Unilever stressed that the foreign subsidiary managed its own business locally, and that the parent company did not give any expert advice about the crisis management policies, etc. So it's potentially there is at least some space now to look at routes 3 or 4 for future cases. So we of course can't speculate on how Unilever would be decided, but at least there is some potential to see what sort of public statements the company gives about operating in this potentially hostile environment, or what the group-wide policies say about it. But it's important to reiterate that these are very fact-specific. This is a very fact-specific area of law, and a lot will depend on the actual circumstances of the case. And at this point, it may be safe to say that it's a lot more challenging to establish parent company duty of care when the acts are committed by the third parties and not immediately result from the subsidiary's operations. Now, the situation becomes even more complex when parent companies are complicit in wrongful acts, and the case that I want to point out your attention is Kalma versus African Minerals, which concerned an unrest over operation of the largest iron ore mine in the north of Sierra Leone, and the parent company I think requested police interference in this case, and police has responded violently, and the claimants, the local community, were beaten, shot, robbed, sexually assaulted. And during these incidents, the parent company made payments to the police, and that was established during the trial, and they have already also provided them with other assistance in the form of the vehicles and accommodation. And the victims of the attack brought the claim in the English courts on several law grounds. If I recall correctly, there were 7 different bases of liability at the start in the High Court, and then the Court of Appeal has focused exclusively on common design and duty of care. So this case raises a question about appropriate rules of accessory or secondary liability, where involvement in the commission of the crime is indirect and amounts to provision of goods and services. Different jurisdictions use different terms to describe this sort of behavior. Could be called joint tortfeasor or aiding and abetting, solicitation. In the English law, the one of the appropriate grounds is the tort of common design, and this tort provides that where a person commits with another one a tort in furtherance of common design, both actors could be held liable. The tort requires 2 ingredients, assistance and intention, and the Court of Appeal in Kalma case found that indeed, while the parent company was providing some assistance to the police, it did so to restore and keep the peace, rather than to direct or instigate police to commit crimes. So that was not an intention, and then it means that the parent company was not held liable. But back to the duty of care, This argument was also pleaded as an alternative basis, but it was never at the forefront of the claimant's case. And the judge noted that this was not a situation which easily fitted into the established authorities in this area, and the claimant's counsel also accepted that the facts of the case were pretty unusual, and he couldn't point out directly any existing authority. And this case, of course, was pleaded on the merits after Vedanta, but we can see that the factual pattern is very different, which on first sight makes me think that the Shell jurisprudence will not be of any particular influence in this type of cases as well. And so overall, this judgment confirmed that legally businesses operating in challenging environments are entitled to seek protection from state security forces. And before I move on to the next point, just want to very quickly say that the accessory liability is, and I think the corporate complicity, and particularly the interplay between corporate complicity and civil liability, is one of the most controversial and underexplored areas of the business and human rights field. And in Oxford, I coordinate and with my colleagues, we run a project on civil liability for human rights violations. And last year we have received 17 country reports, and the section on accessory liability was underdeveloped in most of them. And particularly because many jurisdictions do not distinguish simply for the purposes of civil law between primary and secondary tortfeasors, but also those which distinguish, the case law is so limited that practically we still can't say what are exact rules that should be applied. And I know that the University of Amsterdam is running a very interesting project on rethinking secondary liability for international crime. So we'll be looking forward to see some insights coming out from there. Now, what happens next? And we have seen that there are a few questions from the audience about the forum non-convenience control. So when the case was released, when the judgment was released last Friday by the Supreme Court, several news agencies has reported that Supreme Court said that the case can proceed in the English courts. Well, that's not entirely what has happened. And Matthew has already reiterated that claim against foreign subsidiary was brought under English law, and there are a few challenges to meet in order to establish jurisdiction. And so far, the discussion was focusing around whether there is a real issue between the parent company and the claimants, which is reasonable for the court to try. But the Supreme Court said that the High Court should now address other jurisdictional challenges that may be maintained by the defendants. And quite often in this sort of cases, we saw that the defendants tried to establish, and I highlighted in red, that England is not the proper place to bring the claim, and instead the foreign forum, in this case Nigeria, is a more available one. And this rule is known as forum convenience or forum non-convenience rule, depending at what stage of the proceedings the question arises. And it is resolved by the Spiliade test, which has two stages. First, the English courts look at various connecting factors to see where the natural forum of litigation is, so which is the most appropriate forum, where the real and substantial connection is. And then they look, if it's the foreign state, they look at if substantial justice is available in this state for the claimants. So the way the case proceeded in Vedanta is the court said that, well, Zambia is the most appropriate forum for the claims against both the parent company and the subsidiary. It couldn't strike out the claim against the parent because it was brought under Brussels I regulation recast, but it could still strike the case against the subsidiary. But then it said that, well, because the claimants are Zambian rural farmers who don't have access to funding and experienced lawyers in Zambia, the case against both defendants will proceed in England. And we can expect that if the corporate defendants maintain this jurisdictional challenge, that the court will have to look where is the appropriate forum, and likely, based on the previous jurisprudence, the court might say that Nigeria is indeed the forum where the connection is, and then the court will have to see if Nigerian farmers can access justice in Nigeria. And as far as I understand from the claimant's appeal to the Supreme Court, is what they're pleading is that justice is not available to the claimants because of the extraordinary delays in legal proceedings, which are characteristic of the Nigerian system. And very briefly, just 1 or 2 minutes, is what happens after Brexit. Well, after 1st of January 2021, the Brussels framework ceased to apply and the UK has reverted to domestic rules. There is still some possibility for the UK to join the Lugano Convention. It hasn't happened so far, which means that forum non-convenience control is now available against both defendants, which is potentially a barrier to meet. And there are a lot of writing that are saying why forum non-convenience control is a barrier. It leads to lengthy and expensive jurisdictional battles. Burden of proof is on the claimants, and the English courts are required to make an evaluative judgment and to compare to different systems. And when they're asked to compare the legal system of another sovereign state, sometimes it could lead to comity considerations, which leads me to make to another statement, is that we do potentially need legal reform that could help claimants and could help to proceed faster to the merit stage of the proceedings. And there are two, at least, alternatives that I see. One is abandon forum non-convenience rules as such, which is what Brussels one did, or revise the first limb of Spiliada test. And I'm now finalizing the article very soon in one of the journals. It's at the final stage of review, where I suggest some analysis. And I think that a way forward, one of the ways forward at least, is to move from looking at the most appropriate forum in this type of litigation to focusing why England is clearly an appropriate forum, and also to focusing more on the connecting factors that link the case and the parties with England, such as a breach of duty of care within jurisdiction. And what I find particularly amusing from the Supreme Court decision in Vedanta is that the Supreme Court made some very groundbreaking and very progressive statements about parent company liability and how the duty of care may be owed by the British company based on the different interventions exercised within the jurisdiction and exercised in England. And then next stage saying that, well, but we won't look at this case and it might be more appropriate for another state to look at it. And I just think that we should think about, well, about the underlying characterization and underlying claim of these cases, is that largely these cases are about what parent company did or did not do in England. And this is where the connection is with the forum. But I will stop here and let Gabrielle to pick up on some of these issues as well.
Thank you, Katja. It was fascinating to hear about, for me particularly, the issues of accessory liability and the lack of, knowledge and research in that area. Not lack probably, but having little research in that area. It could make an interesting PhD for someone maybe. So our next speaker is Gabrielle Holly. She's a senior advisor in the Danish Institute, senior advisor on human rights and business in the Danish Institute for Human Rights. She's a business and human rights specialist and an experienced commercial dispute practitioner, having practiced for many years at Magic Circle firms in Australia and the UK. Before joining the Danish Institute, she was a senior associate at Omnia Strategy, where her practice focused on business and human rights and public international law, and a researcher in the business and human rights at the British Institute of International and Comparative Law. She recently acted for the Core Coalition and the International Commission of Jurists in their successful intervention in the Supreme Court appeal in Vedanta and Lungo. Concerning parent company liability and the relevance of international standards to the development of UK tort law. She's an Australian qualified lawyer and holds a Master of Laws with distinction from the LSE and the combined Bachelor of Laws and Bachelor of Arts with honours from the University of Western Australia. Gabby, the floor is yours.
Thank you, Anil, and I just want to add my thanks to the thanks already given by the other panelists, to you and to Tara, for organising this with such extraordinary speed, and it's been a really rich discussion so far. So thank you again, as well to my other panelists. I'm going to just quickly pop up a presentation. Right. So what I thought I would do with the benefit of the final slot of the day is focus on a little bit the challenges for claimants and the implications of this sort of emerging line of case law for mandatory human rights due diligence developments. So it'll be a slightly where do we go from here discussion. As I said, what I'll focus today is on a couple of the challenges for claimants that remain, and I think I'll build a little bit on Katya's very good summary of the forum non-conveniens challenges. I'll also briefly touch on the challenges around evidencing these claims that have been happily recognised by the court in this case, and the challenges around delay. This is a non-exhaustive list of the various challenges that claimants face in bringing these kinds of claims. We've, I think briefly touched on applicable law challenges, challenges around the cost of litigation, a rough lot of different challenges. But for the purpose of today, I'll focus on those three. And I think that one of the things that struck me about the decision in Okpabi, which built very well on Vedanta, is that it for me casts in sharp relief the need to really develop alternative routes to remedy and accountability here, and for civil liability to be, I think, a last resort and a kind of a way of filling gaps. It's quite clear that in light of the extraordinary delays that the claimants have faced in bringing these challenges, the up till now quite inappropriate threshold that they're being asked to meet in order to evidence their claims at the jurisdictional stage, that there are still significant problems that remain, and I think there's a real need to develop alternative mechanisms. And then finally, I'll touch very briefly on what these cases mean for developments around mandatory human rights and environmental due diligence. So to begin with the good, I think that it's important to acknowledge that as the other panelists have, that these are very positive developments in the case law. I think that both the Vedanta case and the Shell case have clarified a pathway to liability by the application of ordinary tort principles. And I think that it's a really, again, a really positive development to be kind of liberated from the straitjacket of Chandler, as the court put it in Vedanta. There's no longer a requirement for claimants to shoehorn their claim into the Chandler indicia, which I think has been an uneasy fit for some claimants in the past, and may in part explain the challenges faced by the claimants in the Unilever case. I think it's also extraordinarily positive that we now have a court acknowledging the breadth of the potential liability of parent companies, as Matt alluded to, by either a route of control or by assumption of responsibility, which includes by making representations as to supervision exercised over a subsidiary. And I think that also what we see here is that we've got confirmation that tort is, I think, sufficiently flexible to keep up with the times, maybe albeit with a bit of a lag. And I think that it can really respond to increasingly creative company structures and other kind of fact patterns, also including potentially involvement of third parties. So I think that's the good. That's the good that we see here. And I think it's a big but. And I think that with so many helpful clarifications that we see in the kind of overture in these cases, I think we can gloss over the challenges that remain for claimants here. And I think as Katya mentioned, in reality, the Vedanta claimants really only narrowly survived their jurisdictional challenge, I think by the skin of their teeth, quite frankly. The Supreme Court was very clearly of the view that Zambia was a more appropriate forum, and they got through on the funding point. And I think I completely share Katya's view that I think it's distinctly undesirable for the court to have mapped out a fairly clear pathway for a claim against a parent company in relation to the acts of a foreign subsidiary, and then apply a forum non-conveniens rule, which makes the jurisdiction largely inaccessible. That would mean that these claims would remain largely theoretical by the application of a restrictive rule on jurisdiction, which I think is clearly crazy. So just to build a little bit on, I think, Katya's comments on how we might potentially evolve the law in this area in the UK. I think that there are a few silver linings to Brexit, but perhaps this is one, and we could potentially use this as an opportunity to reconsider the rule in Spiligator. And it may be somewhat parochial of me to propose a rule from my home jurisdiction of Australia, but I'm going to do so anyway. So in Australia, when a defendant is applying for a stay on the grounds of forum non conveniens, rather than having to prove that there is a more appropriate forum somewhere else, they are required to show that, that Australia is a clearly inappropriate forum. And that comes from a case called Botham Manila Flour Mills from 1990. That's been subsequently built on in subsequent cases, and we see from a case Renshaw and Zhang that I've referred to here that realistically meeting that is exceptionally difficult. So here they say a stay on forum non conveniens grounds would only be successful where to allow the trial to continue in Australia would be productive of injustice, oppressive in the sense of seriously and unfairly burdensome, prejudicial or damaging, or vexatious in the sense of productive of serious and unjustifiable trouble and harassment. So in practice, that is an extraordinarily high bar and almost impossible for a defendant to meet. This rule is not without its controversies, certainly among certain members of the judiciary in Australia. In the Renshaw case that I've cited here, there was some dissent, including from Justice Kirby, who, for those unfamiliar with previous members of our High Court in Australia, is a bit of a darling of the kind of lefty law students, always considered to be quite progressive and frequently attacked by conservative media, alleging that he'd engaged in judicial activism. But even he took a very conservative approach and kind of decried the fact that this was the rule in Australia, and expressed a fervent hope that we might one day return to the rule in Spiliator. So that is to say, this rule is not without its detractors, but I think it is a good one and one I'd like to advance. And because I think that it also, avoids a lot of the jurisdictional fights that we see having played out in particular in the UK courts. And I think that it sort of reduces the potential delay that will be suffered by claimants. So provided that the claimant can make out one of the nexus requirements, and in most Australian jurisdictions, you have a jurisdictional hook where damage has been suffered in the jurisdiction as a result of a tort whatsoever occurring, you can generally proceed. So I'll not go on about it, but I think that's a very good rule for it to adopt and one that should be given consideration in the UK context. Just to say one more thing, I think that the Australian example is a good one to point to to make a counter argument against the suggestion that a rule in this form would open the floodgates to claims in the jurisdiction. In reality, there's been a handful of these cases being brought in Australia, despite this enabling environment that favours claimants by this application of a forum non conveniens rule. So there's a case brought against BHP as a result of environmental damage caused by the Octedi mine in Papua New Guinea. There was a early aborted attempt against Anvil Mining brought in Western Australia concerning their involvement in the Kilwa massacre in the DRC, and then there was the Manus Island class action. So there's been really very few of these cases that are analogous to the Vedanta and Shell cases in the UK. So to turn very briefly to the evidentiary challenges, I think it's extraordinarily positive that the Supreme Court has recognised the reality and the obvious importance of internal corporate documents to evidence in cases of this nature. I think that often the judiciary can be somewhat removed from the realities of litigating these kinds of cases and evidencing claims. And I think that it's really positive that recognise the challenges faced by claimants in evidencing cases at the very early stages of proceedings pre-disclosure. And I think that what this case also highlights is the challenges even where there's a mechanism to seek pre-action disclosure. We see the court referring to specific documents that hadn't been produced by Shell that the claimants had become aware of. And it's very hard to become aware of the existence of a document without the good fortune, I think, of a whistleblower. It can be very difficult to evidence these claims where there are unknown unknowns, given that generally when you're making an application for pre-action disclosure, you need to be very specific about the documents you're seeking in order to be successful. And lastly, delay. It's taken 5 years to get to this point, and all it's really an issue in this decision was whether the lower courts had applied the wrong test. And I think that it's kind of crazy that it's taken 2 appeals to correct what I think was a fairly clear error as to the threshold to be applied. And there's still a potential for further interlocutory applications. So I think this is just another example that, as this case has caused me to reflect on, of the extraordinary challenges that are faced by claimants in bringing these cases. Which brings me to the need to develop alternative routes to remedy and accountability. As I hope I've emphasised sufficiently so far, I think it's extraordinarily positive to see the case law developing in this direction. But there is a really dire need to make available alternative routes to remedy that are accessible and expeditious. The challenges around delay, around evidencing claims, around jurisdiction, I think are real. And if there are an easier pathway to remedy, I think claimants would take it. I think it's clear that litigation of this nature needs to be, I think, an option of last resort and one to fill gaps that other mechanisms to remedy are unable to fill. So I think as the UN Working Group on Business and Human Rights sort of refers to it, there should be a bouquet of remedies. And at the risk of maybe being a bit twee, I think to jump on that analogy, I think that litigation of this kind needs to be like the baby's breath in the bouquet that sort of fills the gaps in between other mechanisms to remedy, but is nonetheless critical in really tying the bouquet together, and albeit in perhaps a retro kind of way. So I agree that civil litigation is an important component of the kind of ecosystem of remedy, but it shouldn't always fall to rights holders and civil society to force a change in corporate behaviour. And I think that again, this case really highlights the need for states to fulfil their Pillar 1 and Pillar 2 duties by enacting and enforcing appropriate regulation and providing or facilitating access to effective remedy. In terms of other alternative mechanisms, it's a bit short on time to get into that now, but I would refer you to the OHCHR's sort of excellent projects on accountability and remedy that sort of map out these sort of other mechanisms that might be available. But that might be a recourse to ombudspersons, specialist tribunals, setting up compensation schemes, and as we'll get to in a moment with the last couple of minutes, mechanisms attached to mandatory human rights due diligence. So, and to pick up a couple of the questions that came in through the chat, they're very good questions at that. I'd like to briefly touch on the kind of the links between the developments in mandatory human rights due diligence and the recent developments in the case law. I'm going to assume a little bit of knowledge in the crowd and refer to frameworks like the UN Guiding Principles. So apologies for those getting lost in the conversation who may not be as familiar. I'll start by saying that the human rights due diligence and frameworks like the UN Guiding Principles and OECD guidelines and other relevant international frameworks aren't generally relied on in the case law. There are very few examples where the court has noted the voluntary assumption of a framework like the voluntary principles on security and human rights as being relevant to whether or not there's been a failure to meet a relevant standard of care. That you see that in the Extrada case, and I believe the Kalma case that Katia referred to earlier. But generally, courts don't really refer to these international frameworks in developing this sort of duty of care, and that's not because they've not been made aware of them. Certainly the intervention that I assisted in that the Core Coalition and the ICJ made in the Vedanta case, we drew the court's attention to the UN Guiding Principles and other relevant frameworks. And made a submission that the tort law can and should evolve in line with these developing international standards. And a similar application was made in relation to the Okpabi case. And I think that it's not necessarily a bad thing that the court hasn't referred to those international standards in these cases because they found a kind of a clearer and easier pathway by the application of ordinary principles and didn't feel the need to reach for international standards in order to establish a potential pathway to liability. But I think that as mandatory human rights due diligence is starting to firm up and we're seeing it emerge in a number of different jurisdictions and potentially at the EU level, I think it's something that courts are going to need to start to grapple with more than they have in the past. And I think there's going to need to be a little bit of capacity building on the part of the judiciary to educate them about this particular emerging area. So I think that on to the second point, I think these case law developments are very relevant to the design of liability mechanisms that might be included in a future mandatory human rights due diligence measure. So I think that drafters could take inspiration from the model of control or assumption of responsibility that we see articulated in OCPABI. I think that would be a very interesting development. And I think that, as a couple of people have noted in the chat, there are a few potential challenges arising from these judgments, by creating pathways to liability based on actual kind of interference with the management of a subsidiary, or indeed through representation that you exercise a degree of supervision, even where you don't do it in practice in, say, for example, a sustainability report. Both of those pathways have a potential kind of chilling effect on corporate behavior. The first pathway, actual interference with the acts of subsidiary, may encourage a parent company to retreat, whereas the kind of obligation, the pathway to liability, which may arise by virtue of disclosure, could encourage companies to retreat from their disclosure obligations. As Katja very rightly pointed out, there are a number of obligations on companies already existing under law, which require them to disclose certain non-financial matters. And I think that, but there is still a residual danger. I mean, I completely agree with Katja's assessment that there are a number of different levers that's encouraging companies not to behave in that way, whether that's through investor pressure, consumer pressure, the existing regulatory regime. But I think that nonetheless, to me, it highlights the need for mandatory human rights due diligence obligations to be enshrined in law. And we're seeing developments certainly that are looking positive at the EU level and at national levels, certainly with the announcement from Germany last week, albeit the fact that they'll be introducing a mechanism that doesn't include civil liability. So I think that to round up, and before I close out, I think that civil litigation, obviously crucially important to give teeth to any potential mandatory human rights due diligence mechanism. I think that when you're dealing with a due diligence obligation that is incredibly broad, and I think along the lines of the one that's being proposed at the EU level, in that it would apply horizontally, cross-sectorally to all internationally recognized human rights, environmental standards, potentially social and governance issues. You're applying that broad obligation onto quite a complex regulatory environment. And I think that one of the easier ways to manage that is by putting in place a process-based regulation, which requires companies to put in place a specific process for managing their human rights and other impacts, an example of which you can see in the French law. But with any kind of process-based regulation, I think you have the problem of checkbox compliance as a real possibility. And I think that human rights due diligence is only going to help play a preventative role and encourage a change in corporate behavior that might avoid the harms of the kind that we've seen in these cases so far, if there is meaningful engagement in the process by the companies. And I think that civil liability is a very powerful lever to encourage that kind of meaningful engagement. I'm sure I'm over time, so I'll stop there, but looking forward to the question and answer.
Thank you, Gabby. Thank you. Yes, you were over time, but so was everyone else almost, except for Matt, I think. So, I mean, being over time is expected in these events, but I'm sorry for our audience for waiting so long to have answers to their questions. I think some of the questions have been answered through Gabby and Katja's presentations on the human rights due diligence and some procedural aspects, but I'm going to go over questions, and I will also ask our panelists if they have any additional comments. But I want to just start with first some of the key questions that haven't yet been addressed. And I think the first one is a question from Anna Beckers. I don't know if she's still here, but thank you for waiting, Anna. The question of whether the Vedanta and OCPABI rulings can be extended to supply chain cases. And I will do a shameless promotion. I did write a blog post on this question, actually, in Opinio Juris when Vedanta came out. And I think yes, but I think it's harder. But I'm going to leave it to our panelists to reflect on this. So maybe I can start with Matt, who's actually has been working on various cases. So what are your what's your feeling on this?
I'd agree with you, I think, Anil. I'd say yes, absolutely. Potentially harder. You had in Okpabi, the Supreme Court, for example, at paragraph 147, identifies that a parent company, in a sense, all parent companies control their subsidiaries and have the opportunity to get involved in their management. So that might not necessarily follow with a buyer and a supplier. So that might be one factor to consider, the extent to which the buyer has control over the supplier. But I think absolutely the principles could apply. As the court says, there's nothing particularly special about the parent subsidiary relationship. It's just about liability for the acts of a third party. So I would say yes, definitely, but potentially not as obvious.
Thank you. Do we have anyone else from the panelists who would like to reflect on this, or are we in agreement? Yeah, okay. I mean, one thing that I would add is maybe there might be a bit more anxiety around allowing supply chain claims to go forward in terms of floodgates, because obviously a company can have a lot more suppliers than they have subsidiaries. But yeah, I agree that it's definitely possible. And the fact that Vedanta clearly said that the test they were applying was not specific to parent company relationship, parent subsidiary. There was nothing that special about that relationship. So hopefully that answered that question. But I guess we will see when Lide brings a case like that, and that I think there's probably ongoing litigation. I'm not sure on tobacco. I don't know if that's at which stage that is, but hopefully we will see how such cases proceed. We have a question from Russell Hopkins, and that's for Matthew. He's congratulating you. You might have seen that. Are you able to tell us what those remaining challenges are in the Okpabi case and what the next steps are likely to be? Do you have any observations on English courts' apparent failure to resolve such challenges years after the claim was launched?
Yeah, absolutely. So in terms of the remaining jurisdictional challenges, so firstly, a point I just wanted to clarify is that there are no jurisdictional challenges left in the claim against Royal Dutch Shell. And the Supreme Court in Vedanta, when it's talking about forum, that did not apply to the claim against Vedanta PLC. So that the issues of forum are only relevant to the question of whether the subsidiary can be joined in those claims. So it would be open to the claimants to proceed just against Vedanta PLC or Royal Dutch Shell, and there would be no issues of forum. So those trials could go ahead. In terms of the remaining challenges would involve, though, potentially whether England is the proper place to bring the claim against SPDC, which is part of the necessary or proper person test. A potential difference with Vedanta is that in Vedanta, the court highlighted as pretty crucial that Vedanta PLC had agreed to submit to the Zambian jurisdiction. And in the Shell cases, I don't think Shell has yet made that. They haven't yet made that commitment. So if they don't agree to submit to the Nigerian jurisdiction, then potentially it will be harder for them to argue that Nigeria is the appropriate forum, because the claimants could have chosen to sue SPDC and RDS in Nigeria. So potentially a difference there. But as other panelists have said, it could come down to an argument as to whether the case could be tried fairly in Nigeria. And the claimants in those cases say no, it couldn't, in significant part because of the staggering delays, catastrophic delays, I think the UK Court of Appeal said recently in relation to claims in Nigeria. And so potentially that will be a question the court needs to resolve. In relation to the claim against SPDC, the claim against RDS will go ahead, notwithstanding the result of that decision. And in relation to any observations on the 5 years, I think the fact that Vedanta was preceding the Shell cases contributed to that delay. So the Supreme Court wanted to wait until they'd handed down the judgment in Vedanta. They then invited the parties to see if the Shell case could be resolved without a hearing. Shell didn't agree they could be, so we proceeded to a hearing, but to some extent that has added to the delays. Obviously, we would much prefer for things to progress more quickly, and it is unfortunate, but equally it's not the 35 to 40 years you might be looking at if you're trying to bring this claim in Nigeria.
Okay, thank you, Matt. There's another question for you from Claire Bright. When the case was filed pre-Brexit, would a revision of the Brussels I recast regulation allowing to bring connected claims against both the parent company and the subsidiary have, in your opinion, simplified the proceedings so that it would not have been necessary to go through the test of whether there was a real issue to be tried, etc.?
I'm not sure if that amendment is sort of pending or if it's just speculation. Would that have made a difference? I mean, had there been a provision in the recast regulation saying connected claims against the parent and subsidiary can be pursued, then I suspect that would have been helpful. I mean, the reliance on the recast regulation from the claimant's point of view in these claims is it gives the claimants the right to sue Royal Dutch Shell in the UK courts as of right, so without any foreign questions. But in answer to Claire's question, if I've understood it rightly, I think that would have been helpful had it existed previously. No, I don't think no changes now to the recast regulation retrospective changes wouldn't, I don't think, assist the claimants.
Okay, I think Lucas wants to come in on that one. Thanks, Matt.
Yeah, I think part of the answer you can always also see in the comparison between the English cases and the Dutch case, because the Dutch procedural provision that I referred to in my presentation, so Article 7 of the Code of Civil Procedure, that was the basis for extending jurisdiction over SPDC. That resembles the Brussels I regulation, I think, much more closely than the English necessary and proper party gateway. It basically allows courts to look at the similarity between the facts in the case and also the similarity between, but not necessarily, they don't have necessarily be the same, but the similarity between the grounds for the claims against the different defendants, but not necessarily for a very substantive dive into the strength of the claim against either one of the defendants. And it's up to the defendants to show that the claimants committed abuse of process by filing the anchor claim against the parent company. And that's what Shell actually tried to argue in the first instance and also with the interlocutory decision. And the court said, well, no, because for abuse of process to take place, you need to have like a completely empty, unarguable claim. And that is in this case clearly not the case. And I think the way that the UK Supreme Court now sort of lowered the bar in Okpabi, I think moves it much more closely to how at least the Dutch court have approached this problem, this sort of connection problem and strength of the anchor claim. But I think if that construction, the combination between less of a dive into the substance and also a different bar for joining cases and joining defendants would have been available, I think that would have made it somewhat easier.
Thank you, Lucas. I'm going to move on to the next question, and I'll ask that one to Gabby. So the question is about whether the panel thinks this case highlights the need for fiduciary duties of corporate directors to include a positive duty to take ESG issues into account. I'm going to actually not bring that HRDD law aspect of that question because I think that's answered. But what are your additional reflections on the question of fiduciary duties, Gabby?
Yeah, I think that the director's duties question is an interesting one and one that we've certainly been grappling with a bit when responding to the European Commission's consultation on the Sustainable Corporate Governance Initiative. I have some real reservations about that. I think that there's, no harm in in bringing directors' duties in addition to a mandatory human rights due diligence obligation on the company. But I think that if we're proposing something along the lines of a kind of enlightened shareholder value model, like you see in the UK, like in Section 172, which does require directors to take into account the interests of a range of stakeholders and the long-term kind of effects of decision-making. That's been on the books since, I think, 2006, and it hasn't really inspired a great change in corporate behaviour in the UK, I would argue. And so I think that I don't know that directors' duties alone is really going to cut it personally, basically based on the UK experience. But no harm in having a mandatory human rights due diligence obligation on the company, supported by an obligation on directors, provided that that is designed in such a way as to not create a conflict between the obligations of directors. If there's going to be, if you're retaining a shareholder primacy model, albeit one that takes into account the interests of a broader range of stakeholders, and the obligation on the company to undertake due diligence. So those two need to be aligned. But I think that directors' duties alone, probably not sufficient in my view.
Thanks, Gabby. I'm going to take over Q&A now. And I'm going to answer one question on behalf of the panel. And then if anyone disagrees with my answer, please speak up. But there's a question of, does the panel think Unilever would have been decided differently post Vedanta and Accountability? And the answer is yes, unquestionably so. Unilever got it wrong 7 ways to Sunday. They did the very thing that the Supreme Court really advocates against in Accountability, which is they expected the defendant or the claimants to be able to produce information that the corporation itself held without actually asking the corporation to turn over that information to claimants. So it's that serious catch-22 that claimants have long been in. So if anyone disagrees with me, okay, nope, they all agree. Or they're unwilling to disagree with me. So we're gonna move on to Ronki. You have a question from one of our Essex alumni who is currently now, I think, in private practice. He's finished his LLM. I am slightly quietly advocating for him to come back and do a PhD with me, which is why I'm sharing that with 200 of my closest friends. And that's Kwame Taylor. So Kwame asks, how does a general reliance on foreign investment and expertise, particularly in the oil industry in Africa, inhibit the possible use of BITs to help address business and human rights issues? So I'm going to turn that over to you. You also answered a question already in the chat on the approach of the role of international investment arbitration and dealing with that, if you want to add anything on that as well.
Thank you, Tara, and thank you, Kwame, for your question. I was actually going to type an answer to this question, and I mistakenly clicked on answer live. So the question, let me just reflect on it. How does general reliance on foreign investment and expertise, particularly in the oil industry, inhibit the possible use of BITs to help address business and human rights issues? I think that's a fascinating question. I think that it really depends on what type of BITs we're talking about. I must say, full disclosure, I'm a proponent of significant reform of the types of investment treaties that we have today in any event. As I was speaking, I was saying that I'm not taking an uncritical approach. I'm just saying that some of the things that we're talking about today and that I'm advocating that we could respond to are things that had already been done under bilateral investment treaties. But you're correct that there is that significant reliance in Africa's oil and gas industry on foreign investment, and the arguments around why African states and some other states as well sign the types of investment treaties that they sign. Although, as I was saying earlier, some of these instruments are getting better, but still significantly flawed. So they do inhibit business and human rights considerations. Some have argued that these instruments have a chilling effect on what governments would do. So for example, as we're talking about claimants cases against Shell today, Shell also has a case against the Nigerian government based on a bilateral investment treaty before ICSID right now at this moment. So there's a lot of things, there are a lot of things that go on at the same time that are difficult to connect, but at the same time, they're all quite connected. So I would say that African countries' over-reliance on foreign investment does have a significant impact on a lot of things that we're talking about today. But I think that some of them, the reason I didn't bring them up is because they are beyond the scope of what we are talking about today. So BITs in themselves, could affect negatively business and human rights issues. But I think that an instrument is an instrument. It depends on how we use those instruments. And African states are beginning to decide to use these instruments to further business and human rights questions. So, yeah.
Thanks, Marky. I'm going to ask one question to the panel, and then I'm going to answer a few of the questions myself.
Can I just say something on the arbitration point quickly before we move on?
Of course.
Because you did ask that, right? That question from Mary.
Yeah.
Okay, I just wanted to add just quickly on the arbitration question. I think that apart from the substantive protections that investors get, I think this most recent Nigerian case against Nigeria demonstrates how problematic international arbitration, investment arbitration is in the context of business and human rights, but in general, I think, in terms of foreign investment governance, because it's not possible for us to even know what the case is about. And we may never find out what the case is about and what the ultimate decision is. And it can have a significant impact on the livelihoods of people in the Niger Delta. So I think it is problematic, and it's something that we should abandon. And this is something that I also argue in my scholarship as well. Thanks.
Thanks. When we talk about the significant effect, it's both judicial, but then also really pragmatic, that if they settle without the case going forward, we won't know how much Nigeria is paying to Shell. And that's money that is coming from Nigerians, right? Like, that is coming from their tax base. It is coming from the expenditures towards health and education and infrastructure, even if you want to go down the route of the global war on terrorism, which I don't. It's coming from someplace. It's not money that's just sitting out there waiting to be paid out to Shell, which has already done its fair share of exploitation within Nigeria. So perhaps they don't need to go down that route. Lucas, you have your hand raised.
Yeah, I just wanted to say I have to leave in a minute because I'm teaching at 1:15. So if there's any questions, like quick questions that I can answer right now, I'd be happy to do so.
There's climate change litigation that I was going to ask you. Well, I'm going to ask the panel as a whole as to whether anyone has an opinion about the future implications of climate change litigation.
That is something I have been thinking about ever since that question was posed, and I don't yet have an easy answer to. So I'm happy to leave that to the rest of the panel. Okay. But it's a very good question.
In that case, hang on as long as you want to, and leave when you need to. And we do want to apologize to everyone for going a little bit over time with the Q&A.
Can I just say one thing? Because there were two questions on whether or not these types of cases sort of contribute to neocolonialism, and what the impact is of this being a case that takes place in a former colonizer's country with facts occurring in a former colony. And there's, of course, a lot of implications, but which we'd need 2 hours to discuss it all, which I think we should actually discuss at a later stage, and I'd be very happy to do so. And of course, there's something very strange about the court of a former colonizer deciding whether or not the courts of a former colony are actually good enough to adjudicate cases like this. And just two sort of points that I wanted to make in that respect. The first is that the reason why courts might, and I put this very much between brackets, would not be good enough, is because of impacts of the former colonization. And it's not just England being a colonizer, but also Shell getting its concessions way back when Nigeria was still a British colony. Which is good to keep in mind. So there's however you phrasing it, there's gonna be a colonial impact. And the second thing is that the point that foreign legal system might not be good enough or might not be well adapted to these kinds of cases is made by local communities. And I think that's a quite an important one to keep in mind. Of course, they have to do so within the substantial justice test under SPDC. I know that. But it's a point that they've been making all over the place in all kinds of different fora. And of course, we still have to think about strengthening local justice systems and making sure those cases take place where they actually are the most relevant. But I think we should take local voices and local communities quite serious in that when they make that point, and not just do away with it saying, yeah, but then saying that you're right and that it is indeed that the justice system doesn't function as it should is a neocolonial assertion. So I think it's a complex thing that we still have to sort of keep in the back of our heads.
You jumped ahead in my questions, but I'm glad that you did. Ronki, I'm going to give you an opportunity to answer in a second if you choose to, and if you don't, then we'll move on to the other final thoughts, or onto the climate change question, actually. But I want to answer this as well, because Anil actually sent it to me in the chat saying you have to take this. So on the question of neocolonialism, first, let me start by saying I don't compare modern abuses to slavery, and I don't compare the provision of accessible remedies to colonialism, right? Like when we were talking about colonialism, when you're talking about slavery, those are really specific kinds of abuses of human rights, and they entangle a lot in them. So we need to be really careful about what we talk about when we talk about neocolonialism. The second thing is I think actually foreign nonconvenience is in many ways a continuation of colonial thinking. So it's not the provision of accessible remedies that becomes neocolonialist, but actually it's the use of foreign nonconvenience to manage when and where a corporation will be held accountable. It's this notion that the home state still has a responsibility primarily to the company and not to those people impacted by the company. It comes from this long line of capitalist concerns that claimants will take cases where the law is most advantageous to them. So we have used forum nonconvenience to clap down on forum shopping by claimants. Well, the other side of that is that the corporations have already done their forum shopping, right? The corporations do their forum shopping when they choose where they're going to incorporate. They do their forum shopping when they develop their corporate structures. They do that to take advantage of a wide range of considerations, tax structures, other kinds of benefits, but within those considerations is where is the law most advantageous to them? So they've done that part of the thing. And with forum nonconvenience, what we do is disadvantage claimants in that balance of concerns or legitimate approaches to utilizing the law. So for me, forum nonconvenience is actually much worse than sort of saying, I would actually prefer that they just do away with forum nonconvenience, which Brussels regulation does, because the reality is that's where you see this continuation of we have to protect capital at the expense of people in Zambia or Nigeria. So I would like to see, I think that there are issues, and Lucas was right to raise these issues about the complexity of a former colony deciding whether or not, a former colonial power deciding whether or not its former colonies can adjudicate claims against their corporations. But I think that the answer to that is not in doing away with those substantial justice claims or concerns. The answer to that is doing away with forum nonconvenience, full stop, because that's where you're seeing that protectionism. Gabby, I see your hand up. Ronki, did you want to say anything on this?
Should I go ahead or should Gabby go first?
I'll let you go first and then Gabby will come to you, I promise.
When the question came up, I saw it in the chat. I think that it's a fascinating question. And Tara, I think that you've already started to answer these questions. This is how I see this. I look at things in my work a lot from the lens of three main stakeholders in this area. So there's the state, there are the local communities in the state, and then there are the foreign investors. The state and the foreign investors have a lot of mechanisms open to them. And I've argued a lot in my work that when it comes to local communities, we like to box local communities up. We like to say, this is how far you can go, but not beyond this. And we like to talk about a lot of soft instruments when it comes to local communities. So when the rights of local communities are at stake, especially vis-a-vis capital, our conversations almost automatically go towards soft instruments and alternative ways of dispute resolution. But when it comes to the rights of investors, no one talks about soft instruments anymore. They're binding instruments. There are different forums that they can reach out to. We've talked briefly about international arbitration, investment arbitration today. We're talking millions and millions of dollars in damages. No one talks about this being soft anymore. And to me, it's quite curious when we start to talk about people whose lives and livelihoods are sometimes almost permanently impacted, then we start to say, well, you can only stay within this framework. And I think that people should be given the option to choose. If they choose to bring an action within the host state, it's up to them. If there are mechanisms available within the host state as well, I think it should be up to the local communities to decide where they want to bring their actions. And then sometimes I think that it's a dichotomy. We create these dichotomies that don't necessarily exist. So in these shell cases that we're talking about, in many instances, the local communities aren't just going after SPDC, they're also going after the parent corporation. And to say that you have to stay just within the host state almost takes out the parent corporation from the picture. It just leaves the subsidiary that operates within the host state. So if we just keep this within the host states only, then we almost also automatically omit liability for the parent corporation. We're just limiting it to the subsidiary. And often these communities want to get not only to the subsidiary, but to the parent corporation as well. So I think that just as investors have lots of mechanisms open to them, it is very important for us to get to a stage where local communities also have multiple options open to them and they can choose whichever one they want to go for.
Thanks, Gabby. You want to come in on this?
Yeah, I just had a very, very short point to add to that, kind of on the foreign non-convenience sort of issue. And one of the reasons why I kind of prefer the Australian approach is that I think in some respects it's less offensive to comity in that it requires an assessment of the jurisdiction in which the proceedings are to proceed, rather than an assessment of the appropriateness of another forum. So it sort of flips it around a little to assess whether or not, in this case, Australia is an appropriate forum for the proceedings to continue, rather than doing what the court did in Vedanta and kind of undertaking an assessment of the Zambian jurisdiction. So if we're not to go your route, Tara, and do away with forum non-convenience altogether, I would argue that that's possibly a better approach and one that is a bit less offensive to principles of comity.
I'm going to admit here to my jealousy of the British, Canadian, Australian conglomerate here. Coming from the US, I have no good case law and no good legislation to offer you on any of the issues we're discussing today. So every time you guys kept talking about things from various jurisdictions, I was like, man, I wish I was licensed someplace else. I'm no longer licensed in the US either, just to clarify that, but I was for 10 years and envy those that come from better jurisdictions for these things. All right, the last question I'm gonna finally ask is, and then I'm gonna do a little bit of a wrap up and then we'll go to Anil for the final wrap up. And that's the issue of climate change litigation. Does anyone want to tackle that? Gabby, your hand is still up, so I should warn you that that's a really dangerous thing to keep up. Okay, I think some of the climate change will come. In my answers here, because what I want to talk about is the implications of probably beyond the parent company subsidiary supply chain responsibility, which we've covered a little bit already. And that's to address the impact of this responsibility for end users or end user liability, meaning when you've sold a product or you've invested in a product and that is ultimately used to commit human rights abuses. It's a different kind of a relationship than what we talk about when we talk about parent company subsidiary parent subsidiary relationships or supply chain relationships where somebody's purchasing products that have been made in abusive conditions. But when you think about human rights, this came up in Caterpillar with South Africa, it came up in Caterpillar with Israel, it comes up with the arms industry, and also with financial investors, where people give a product away, whether that's a good like Caterpillar's equipment, or it's money as in financial investors. And while this case doesn't directly address these kinds of considerations, it does give me hope that these kinds of cases can go forward in the UK in the future. And if any lawyers out there want to take a case against the arms industry using general tort law, get in touch. I want to chat with you. The UN guiding principles make it clear that these businesses have a responsibility, that they're supposed to be taking on human rights in their operations, not just in their supply chains, but in their other kinds of operations as well. And that includes with their customers. But unfortunately, prior to Vedanta and Akpabi, what we saw was that the courts generally treated human rights commitments and policies as puffery. They were no different than saying, I have the best car in the entire United Kingdom, come to my lot. And now what we're seeing with Vedanta and Akpabi is actually a switch in our understanding of what human rights policies and commitments are. They're not just another public relations exercise, or actually a statement of how your business is going to relate to the communities that you are going to impact. And there, I think that that's where you can see some of this Vedanta Akpabi dicta, as well as some of the binding portions of it, really open up UK courts for greater litigation in business and human rights. And that's even before we start thinking about mandatory human rights due diligence claims. This raises some complex questions, because what we see with these seller relationships or end user relationships is the same thing that we kind of saw with parent subsidiary relationships in the past. It's this notion that we don't have an obligation to act, and you can't make us act. So we shouldn't have any responsibility for what happens with our products when they're used to commit human rights abuses. And what the Supreme Court is really saying is, you're right, we can't force you to act, but when you choose to, when you tell everyone you're going to, we're going to hold you to that, at least in the establishment of the duty of care question, right? At least to make it an arguable duty of care. We'll have to look at what you actually promise. We'll have to look at what you say and how you say it. But you can't just go around telling everyone we're an amazing human rights company, which is what Shell does, which is what Unilever does, which is what 1,000 other companies do. We're amazing at human rights, just trust us. And then they move on, and they don't actually do anything that they promise. This raises a question about how human rights due diligence impacts these cases. Gabby's covered a lot of this already. I do think that it's important that we keep separate how human rights due diligence legislation will impact versus how human rights due diligence in practice will, right? The French human rights due diligence legislation will actually have an impact. If you comply with it, if you have satisfactory human rights due diligence, you can mitigate your impact. You are not, as a parent company, going to always incur liability. The German law that was just announced, at least according to the English explanations of it that I've read, doesn't actually address civil liability. And what that means is that there's no clarity as to the impact of human rights due diligence on liability. That should be concerning not just for victims and communities and human rights activists, but it should be concerning for corporations, because what the German government is now saying to you is, yes, you have to do that. And no, we're not going to clarify what this has in terms of an impact on your liability. Also, the German government is going around boasting that it is passing the most robust human rights due diligence law in the EU and elsewhere. That's a lie. And I don't mind that the German government is lying to itself. I think we all lie to ourselves when we have failures. I do mind that they're lying to the rest of the international community, because it's not true. The French law, the German law will apply to more companies. The French law in terms of substance vastly outstrips the German law. And Germany, if you want to have the most robust human rights due diligence legislation, I have 1,000 German lawyers who can help you. But you're not there yet. And unless you completely revamp your approach to this, you're never going to be there. The other question is about this human rights due diligence in practice. And there, I actually think we hear a lot from companies talk about there being a catch-22, right? Under the guiding principles to comply, you have to assume liability or assume responsibility. And once you assume responsibility under UK law, you're opening yourself up to liability. This is not a catch-22. This is not even close to the equivalent of what we ask of claimants to figure out what the documents are that are held by the company before they're actually allowed to ask the company for the documents that the company itself holds, right? That's a catch-22. What we're asking of companies is to actually do what you promise you're going to do, right? Don't sign up for the UN guiding principles and then do nothing in terms of human rights due diligence. We keep having these companies come to the UN Forum on Business and Human Rights every year, promise their commitment to the guiding principles, and then we end up with them in courts. And I'm sorry, but with friends like you, we don't need enemies in business and human rights. We don't need to continue to have this. The answer to your catch-22 if you're a corporate lawyer is simple. Do your due diligence well. Because yes, you're getting an assumption of the duty of care. You're seeing that from Vedanta and Accountability. But your human rights due diligence should affect the issue of whether or not you've breached that duty of care. If you've sufficiently done your human rights due diligence and your subsidiary just ignores you, that will be on the subsidiary, not on the parent company. It will address your causation issues and it will address your damages, right? Good human rights due diligence, appropriate human rights due diligence will generally mitigate the impact that you're having on the ground. It will generally involve a mitigation and remediation plan. That means that the damages that you will owe through these court cases are substantially less than if you don't do human rights due diligence. So this seeking of empathy that I hear from corporate lawyers all the time, I mean, I'm sure somebody out there has it for you. It's not going to come from me. And it's not going to come from me because this isn't a real concern. We aren't putting you in a position where you can't comply with your human rights due diligence or your human rights responsibilities. We're not putting you in a position where you can't comply with the law. We're asking you to do what you promise people. And I think if there's anything in terms of what we're looking for with the impact of Vedanta, with the impact of Accountability and their difference, is that with Accountability, I think we finally have clarity from the Supreme Court that says, yeah, these promises are not that puffery. These promises are meaningful. And we're gonna ask you, we're gonna expect you to live up to that. And I think that that language in Accountability, for the reasons that Matthew set out at the beginning, the language in Accountability is much clearer on that than it was in Vedanta. I'm supposed to hand it over to Anil, but I see Matthew has his hand up, so I do want to give him the chance.
Just super quickly, and I don't want to steal your thunder with your brilliant summary, Tara. And I agree totally with what you were saying there. Just the point you were making about the seller end user cases, just to flag that we've been doing one of those, a case called Begum against Mara, which is a shipbreaking case, which I'm not involved in. I think the injuries, the death of the victim occurred in Bangladesh, I think, where the shipping company sold their ship to an intervener who then took it, broke it up in dangerous circumstances, which resulted in the death of our client. And that claim's being pursued, and it was in the Court of Appeal about 2 weeks ago or so. So we are definitely open to developing the law in that direction as well. So I just wanted to flag that, but yeah, no, thank you for a brilliant conclusion.
There is a reason that we're massive fans of Lee Day at the EBHR, and it's because you guys are always at the forefront of these kinds of cases. And Nil.
Thank you, Matt. Thank you, Tara, Ronke, Katya, and Gabby, and Lucas, who's not here. I think one thing that we didn't mention at all was the treaty, and I don't want to mention too much of that right now, but I think one way of getting, by way of conclusion, more states to actually be forced to adopt human rights due diligence laws that are of better quality than the German law is to get a good treaty that imposes that obligation on states. And I think the current treaty drafts, with its issues and strengths, it does that to some extent. But of course, we know that there's a long way to go before we can get an actual treaty agreed on and signed and enter into force. So I'm just going to conclude here. We're already way over time. I'm really grateful for our panelists to stay longer than planned, and to our audience, and especially to Ronke, who's, for you, it's like 6:30 right now. Thank you so much for being so smart and lucid throughout this whole event. We are going to, as we said in the chat, we're going to we're recording this event and we're going to upload it. We're going to share it through all the various channels. And if we have any questions that left unanswered, please feel free to drop us a line, and we'll be more than happy to answer questions. And I'm going to conclude the session here. Thanks, everyone.
Thank you very much, everyone.
Yeah, thank you. Great session.
Thank
Thank
you.
you, everyone.